Good morning, everybody. This is Brad Patterson. I'm a partner at the law firm of Ballard Spahr. You were participating in a webinar entitled Municipalities Continuing Disclosure Cooperation MCDC Initiative for Obligated Persons. Are you prepared? Joining me today on our webinar is Matt Duke, a partner at Avant Strategic Partners. Matt has been historically performed arbitrage rebate calculation services, but he's also, as of late, been doing a fair amount of audit work as it relates to compliance with MCDC. So Matt's presence on this call is extraordinarily welcome so he can share his experiences with us. This is the third installment of a continuing series of discussions that we've had regarding the Municipalities Continuing Disclosure Cooperation Initiative of the Securities Exchange Commission. We previously provided an overview of the MCDC program. We will once again cover the basic provisions of the MCDC program, but we'll also provide you with some information that we've gathered from other discussions, market practice, and our own experience with the MCDC program, a topic about which we have been speaking since March. Furthermore, we will have one additional webinar as it relates to the MCDC program that will be held on November 17th. That particular webinar will cover a topic that relates to what will happen upon the completion of the MCDC program and what happens if the SEC comes knocking at your door. The letters MCDC sound a lot like the name of a popular hard rock band from my days when I had more hair and less weight. However, the similarities do not end there. Please indulge me for a moment while I recite some of the lyrics from one of the more well-known songs of that band. The lyrics go thusly: I'm rolling thunder, I'm pouring rain, I'm coming on like a hurricane. My lightning's flashing across the sky, you're only young, but you're gonna die. I won't take no prisoners, won't spare no lives, nobody's putting up a fight. I got my bell, and I'm going to take you to, well, choose a word that rhymes with bell. So what is MCDC? On March 10th, 2014, the SEC rolled out an initiative directed at issuers and underwriters of municipal securities. The MCDC is a quasi-amnesty program that encourages issuers and underwriters to self-report possible violations of securities laws for statements made in offering documents regarding an issuer's past compliance with his continuing disclosure undertakings. The MCDC is the latest in a long line of efforts by the SEC to encourage issuers to comply with their disclosure undertakings and to properly report compliance with such undertakings, the adherence to which the SEC believed was greatly lacking. The SEC had attempted a variety of tactics to increase compliance, and it concluded that such measures were ineffective. In 2013, the SEC took a more eye-opening measure when it brought an enforcement action against West Clark Community Schools. West Clark made a representation in its official statement that it was in compliance with its undertakings that it had entered into pursuant to Rule 15C212, when in reality the district had never submitted any of its reports. The SEC concluded that the statement regarding compliance was a material misrepresentation that subjected the district to penalties under the federal securities laws. The basis for the West Clark enforcement action was the misrepresentation regarding continuing disclosure compliance, and that position serves as the basis for the SEC's Municipalities Continuing Disclosure Cooperation Initiative. As has been discussed before, the SEC rolled out the MCDC initiative on March 10th of this year. The MCDC initiative applies to instances when, during the last 5 years, the issuer made a misrepresentation in its offering document regarding its compliance with its continuing disclosure undertakings. As you all may know, Rule 15C212 requires issuers to provide a statement in its offering statement regarding instances within the previous 5 years of the official statement when it wasn't in compliance with its continuing disclosure undertakings. Many issuers made statements that they were in compliance with their undertakings, when in reality, they were not. The MCDC program is directed at that scenario. Essentially, the MCDC program allows issuers to come clean regarding such misrepresentations and permits them to avoid further and more severe SEC penalties for such statements. If an issuer opts to self-report, the SEC Enforcement Division will recommend settlement through cease and desist proceedings and will not seek financial penalties against the issuer. However, if the issuer has made a misrepresentation regarding compliance with its disclosure undertakings and does not self-report, all bets are off. In such a scenario, and if the SDC becomes aware of the misstatement and decides to pursue action against the issuer, it can take a range of actions against the issuer above and beyond cease and desist proceedings, including the levying of financial penalties against the issuer. Such actions seem far more draconian than the actions proposed by the SEC if you decide to participate in the MCDC program. The SEC, Matt, if you want to go to the next slide.
Oh, sorry.
Thanks. Oh, you went back. And if you decide to participate in the SEC program, you will have to enter into an agreement for a cease and desist order. Essentially, a cease and desist order is where the issuer agrees that it will not commit fraud in the securities market. It's not an admission of wrongdoing. It just states that it will not commit securities fraud in the market. Another part of the MCDC program is that you have to establish compliance policies and procedures. You have to disclose terms of your settlement with the SEC in the official statement for 5 years, and you have to cooperate with the SEC in any subsequent investigations. One thing that you should note about the MCDC program, Matt, you can go ahead and forward to a couple more.
Okay. All right.
There you go.
About that.
Okay, one more, and we'll be there. One more thing that you should note about the MCDC program, it applies only to institutions and not to individuals. The SEC may still bring an action against individuals if it believes the facts merit such action. The SEC has shown a willingness to do so with a recent action just within the last couple of days against a mayor and a former finance director in Michigan. Penalties against individuals could also result in monetary fines against those individuals. Go ahead and forward a couple more too, Matt. Please note, and then one more. Please note that the MCDC does not cover other misstatements in an offering document. It only covers misstatements relating to continuing disclosure. Why are we holding this webinar now? Well, I checked my schedule today, and today is November 7th. The clock is ticking, and the deadline for whether or not you're going to take advantage of the MCDC program is December 1st. Matt, that's your next slide. So you have until December 1 to decide whether or not you're going to comply with your continuous disclosure or comply with the MCD or participate in the MCDC program. As the slide shows, the deadline for underwriters was on September 10th. Matt?
Okay.
I'll let you go ahead and explain what steps they should be taking between now and December 1st.
Yeah, thanks, Brad. And I apologize. I'm driving the ship here, if you can't tell, and I'm not staying on pace with Brad. So over the next few slides, I'm going to cover a very basic approach that anyone can use to evaluate their exposure under MCDC. And the first step involves compiling a list of offerings issued to the public within the past 5 years. And then you're going to want to look at the statements made, if any, with regards to prior disclosure compliance in the offering documents. Even if no affirmative statements with regards to prior compliance were made, if there were prior lapses, a statement should have been made, and that highlighted any of the failures to file. You'll want to evaluate were any statements misleading, and I think the prime example of that is the affirmative statement that West Clark schools included in their OS. And they explicitly stated in the previous 5 years, the school corporation has never failed to comply in all material respects with any previous undertakings. And the problem with that statement is it was absolutely inaccurate, and it's the primary reason the SEC enforcement action was brought against the school district. And I should point out, for infrequent issuers, that if there weren't any new public offerings within the last 5 years, the MCDC initiative probably isn't relevant to your situation. And even if you've issued one, but you had no previous bonds outstanding with undertakings, MCDC may be irrelevant to you. but as we're going to talk about later in the presentation, now's a good time to go ahead and take a look at what you're doing, review your procedures, and shore those up because, again, the regulators, I think, have put such a spotlight on this, it's not going to go away. Step two, the next step, is to confirm that the statements made in the offering documents were indeed accurate. And that involves researching the prior undertakings for all issues outstanding during the 5 years leading up to the date of each issue identified in the previous step. So, for example, if there was a bond issued in September 2009, theoretically, an issuer would need to review all disclosure filings going back to September 2004. And that means, depending on circumstances, the disclosure review may need to go back as far as 10 years. And that's all based on the 5-year statute of limitations. And so, prior to July 1, 2009, filings were posted with the 4 NMCRs. That's the Nationally Recognized Municipal Securities Information Repository. And the problem with that is reviewing filings made with NMCRs are tricky. For one, not all former NMCRs provide access to historical filing reports, and those that do tend to charge a pretty hefty subscription fee to access those historical filings. And one thing that's come out over the last few months, and I think it's pretty widespread, through the community, there are concerns about the quality of information. If you can access one of the former NMCRs, how good is the information that you find in there? And one specific highlight is that it's my understanding that prior to the Emma period, if you submitted something to a NMCR, you may have submitted it in December when your filing was due at the end of December. But you might not see it posted to the NMCR in their database until 4, 5, 6 months later, and that has to do with the process that the NMCRs used to upload the documents that were submitted. And so there's no timestamp as to when the actual document was received, and most from what I've seen, the date stamp is when it was uploaded to the database or the portal that can be accessed. And so that's been problematic with any pre-EMA review period, or any review of the pre-EMA period. And then, of course, on or after July 1st, 2009, all filings had to be posted to EMA, which is free. And so we've had almost 5 years now, or 5 years, using EMA system. And again, there's some tricks to that as well, but the point there being everyone knows about EMA, everyone should be using it, and from the SEC standpoint, there aren't any excuses for not handling your disclosure properly. I've gathered from talking to various issuers that some believe their use of a dissemination agent mitigates most, if not all, of their risk. But I think it's worth pointing out that most dissemination agents don't even look at the content of the filings they post. There's a lot of volume going through there, so as they receive the documents, they may simply post what's provided to them by the obligated person. And it's not uncommon for posting errors, especially in the early years of EMA, posting or indexing errors to occur. And so I think there was a lot of confusion by the issuing community of how to properly post something to EMA during the 2009-2010 timeframe. And that bears out in a lot of the reviews. We see some inconsistencies, and where there's perhaps an annual filing is posted to one bond, but not all bonds. And I think the learning curve was pretty steep early, but it's flattened out quite a bit since then. The next step involves confirming that the filing was made. Confirming that the filing was made is only part of the equation. You should be looking at what's contained in the filing and compare that to the specific requirements outlined in each issue's CDA or continuing disclosure agreement. there may be different requirements for different types of issues or credit types. For example, the operating data for revenue bonds often includes supplementary information that may not be included in the annual audited financial statements. Whereas the requirements for GO bonds may be as simple as simply posting the capper. As you audit, you should confirm that all required filings were made, that they were made on time, and that the content was compliant with the CDA for each bond. And note, and you'll hear me say this numerous times throughout the presentation, that CDAs for the same credit type may change over the years, so it's important to be careful that you don't assume that they're always going to be the same. I know that as we were reviewing at the peak of the season in the summer, there were a lot of, I think in the 2009 to 2011 time period, official statements changed quite a bit. And I don't know if that was because of the financial crisis, underwriters felt like more information needed to be supplied. But the bottom line is there are a lot of changes, and a lot of the folks that we've audited, they just continued to use their old template and failed to update that template for the new requirements. I should also point out that Emma will accept any document you want to upload, even a blank PDF. And I think as one of the Ballard attorneys highlighted, you can post a recipe to Emma, and no one would really know the difference unless they actually click on it and look at it. So again, remember that it's not safe to assume that a filing is complete just because you see it posted. Open it up and make sure that it's what it's supposed to be. It's becoming more common for issuers or underwriters to engage a third party to conduct disclosure audits and issue a formal report. If you do this, be sure that the scope of the review includes a comparison of what was filed against what was actually required by the CDA. Otherwise, you may be asking for hidden exposure that could come back and haunt you. Disclosure events are inherently difficult to evaluate. And for example, how would you verify that an event filing should have been made if the people in the organization currently have no direct knowledge of the event? It kind of goes along with that old saying, if a tree falls in the woods and nobody's there to hear it, did it make a sound? Knowledge is important, and that's very difficult. So I think a lot of the focus has been paid to ratings events, primarily because those events are easily verifiable through simple data mining exercises. And for example, I know the SEC has a backdoor channel into Emma's databases through the what's called the MSRB's RegWeb. So it's likely they can efficiently pull this data out and compare it against other data sets from other sources such as ratings agencies. And so I think the key thing is, what kind of events are verifiable. In a way, you almost want to triage that because otherwise you could, it'd be a wild goose chase trying to determine if an event occurred and wasn't disclosed. After reviewing all the relevant disclosure filings and summarizing any lapses in compliance, including the foot fault, the next step is to sit down with legal counsel and evaluate whether or not MCDC is appropriate. You should recall that MCDC is relevant only if an offering document failed to properly address any prior lapses in disclosure compliance that are material. And one thing I've learned is materiality is a very subjective term. So legal counsel familiar with SEC rules and enforcement actions will be able to help you navigate the murky waters of materiality and shed more light on how self-reporting may open you up to other risks. And Brad will talk about that a little bit more in just a moment. And then the fifth step, after discussing the specific facts and circumstances with counsel, you should coordinate with all the underwriters who helped issue bonds within the past 5 years. And I would say now we're getting closer to the deadline. Yeah, you don't necessarily have to wait on speaking with counsel. Reach out to your underwriters if you haven't already. Again, since the underwriter's financial exposure was capped at $500,000, they were certainly incented to report as much as possible, even when materiality was questionable. So don't procrastinate, because it may take some time to resolve any inconsistencies or differences of opinion. And then I'm going to hand it back over to Brad, and he'll talk more about the potential for unintended consequences and how that fits into the materiality discussion.
Thanks, Matt. Matt's actually done an excellent job of giving you an overview of the steps that you should take in terms of conducting a review to see whether or not you want to take advantage of the MCDC program. But there are a couple of other additional considerations that you will want to factor in before making your decision. We've already talked about some of these. Some of those considerations are, first of all, that the program only applies to statements made with respect to continuing disclosure undertaking compliance. It does not apply to other misstatements that are in the offering document. So that's one thing that needs to be considered as well if you have a situation where you feel that you may have a misstatement in your offering document above and beyond what you had with respect to your continuing disclosure undertaking. It may open you up to further scrutiny from the SEC and could bring about an additional enforcement action outside of the confines of the MCDC program. Another factor is that we've talked about before is that individuals cannot self-report, and what it means is that the program doesn't extend to individuals, and so people may be a little bit hesitant to go ahead and call themselves out for a violation if that means they could have an action taken against them. The other thing is that you will be influenced by the fact that more severe penalties can be sought. As we've talked about with respect to the MCDC program, the current penalty is a cease and desist order, and you have to take certain additional steps in addition to agreeing not to commit securities fraud, but you have to set up compliance procedures and policies. You have to report back to the SEC, and you have to provide a statement in your offering document for 5 years. That's the MCDC way. Outside of the MCDC, you have other additional severe penalties, such as being banned from participating in the securities market and financial penalties as well. So you've got your report back from Matt, and you're taking a look, or whoever you had conduct your review of your past continuing disclosure undertakings, and you're needing to make a decision about whether or not you're going to participate in the MCDC program. Now keep in mind that the MCDC is a voluntary program, and so you need to go about, after all these other determinations are taken into account, you need to decide whether or not you're going to report. As Matt mentioned, one of the first considerations in deciding whether or not to report is the concept of materiality. Unfortunately, the SEC has not provided much guidance on this one. The standard on materiality, Matt, if you go to slide 18, is one basically of a reasonably prudent investor. And not only is it one of a reasonably prudent investor, there's an additional factor, and that is if omitted information is considered material, if there's a substantial likelihood that the disclosure of the omitted fact would have been viewed by the reasonable investor as having significantly altered the total mix of information made available. That is a rather unique standard, and we're really not quite sure how the SEC would apply it because they have not given us any guidance on that. To this point in the process, and I'm sure Matt can testify to this, we have seen the entire spectrum of scenarios, some of which are material and some of which are clearly immaterial. On one side of the spectrum, you have somebody who says they have filed and have never filed anything. On the other end of the spectrum, you have an issuer who said it was compliant and missed a filing deadline by maybe a day. These cases are the rare ones, and what we see is everything else in between. Factors to be considered in materiality, slide 19, are the importance of the information to be provided, the extent to which the information was available in other places, the length of delay for late filings, the reason for the failure, Is there a pattern of failures? When did the failures occur? And are there now policies and procedures in place? Other factors to consider in self-reporting is whether or not the underwriter itself has filed a report with respect to your issue. As noted in an earlier slide, underwriters had a deadline of September 9th, and so they have already filed. It is prudent to reach out to the underwriters, Matt suggested, to see if they have filed. Not necessarily does the filing by an underwriter mean that you have to file. It just once again increases the risk that the SEC may decide to come after you. There's a risk analysis that needs to be performed in all of these determinations about whether or not to self-report, and the fact of an underwriter reporting is just one more factor to add to that mix. Another consideration is whether or not the issuer itself is prepared to file, including dealing with any negative publicity. In certain instances, we've had issuers tell us that they would file, but they are worried about some negative press. And so they are willing to go ahead and not file and take their chances that they have a good position if the SEC were to come and investigate them. As we've consulted with our clients on these issues, Matt, I'm on number 21 now. As we consulted with our clients on the issue, a few additional questions regarding self-reporting have arisen. These questions are, how does this normal process differ from the how does the normal SEC enforcement action differ from MCDC? Well, as we talked about before, there's further investigations as it relates to an SEC action. They will come in with their folks and they'll investigate you. It can be a disruption in time, and it can be a disruption in resources. And so the ease of the MCDC initiative may appeal to some issuers. Questions are, will there be an opportunity to discuss the self-reporting with the SEC? There will be, but we're not quite sure what the nature of those conversations will be. You need to ask yourself about conflicts. Is the issuer making a determination also the issuer official who is named in the questionnaire that's submitted to the SEC? Is the issuer official who is considering self-reporting prepared to bring that decision to the appropriate officials or elected body of the issuer if necessary, and to explain the recommendation? And then lastly, is it okay to use counsel who is involved in the original transaction where the misstatement was made? Related to that last one, I would tell you that there's not a problem, but some people may feel otherwise. There are a few other items to consider. For example, there's a 5-year statute of limitations for seeking financial penalties. And another thing that should be borne in mind is the filing of an MCDC report in and of itself is treated by, it should not be treated by the SEC staff as an offer of settlement or admission of liability. At the end of the day, it's best to take these various items to consider, sit down with your counsel and make a determination as to what may be best for you. At the end of the day, it boils down to a risk analysis, and you have to make a decision about whether or not the risk is worth it for you. Matt, do you want to go ahead and wrap up? Yeah, I'll go ahead and talk about some things to consider even if you don't report and how to shore up those procedures. At the risk of sounding like Captain Obvious, I'm going to highlight a few of the most important aspects of establishing effective procedures. And my focus is going to be on procedures rather than policy because, quite frankly, that's where the rubber meets the road. And I think besides having a sound playbook that your team can easily execute, the use of narratives and high-level flow charts and they improve the overall functional understanding by every member of the team, and it facilitates better training and continuity when there's staff turnover. And so when you document detailed procedures, I know it's a lot of work, but I promise you it's worth it.
and I'll highlight a few additional benefits. And for one, process improvement and the elimination of waste, it's much easier to carry out if you have well-documented procedures. And I think probably most importantly, the regulators have suggested that they'll go easier on an issuer that has well-documented procedures. I think the obvious implication there is that the procedure should be followed. And while I don't have an empirical study to point to, I can tell you anecdotally from all the reviews we've performed over the last several months, the issuers that had very detailed procedures absolutely demonstrate a much higher level of compliance than those that didn't. And so, now that I've talked about why these procedures are so, documented procedures are so important, I'm going to highlight a few things of what's the most important to cover in those procedures. First of all, procedures should clearly identify who the process owner is, and that person should not be a third party, even if the organization delegates much of the work to a third-party consultant or a dissemination agent. I think it's a good idea to have the same person or process owner be responsible for both primary and continuing disclosure to ensure consistency across transactions. And as I mentioned earlier, CDA requirements evolve over time, and a well-controlled process ought to include a reconciliation of prior requirements with the new requirements before a new offering document is released. And in a few slides, I'll provide an example of a very simple tool for tracking CDA requirements that can also be used to reconcile and as a checklist for each annual filing. Procedures should also identify who will provide the various inputs to the disclosure filing. There may be a lot of different departments. It could be just the accounting and finance department, but the larger the organization, the more likely it's going to require reaching out to people and different silos, and just establishing that communication and keeping it there on a continuous basis is quite a challenge. We should talk. I think you should identify who prepares, who reviews, and who posts to EMA. I don't think it's smart to have the same person do all three, but again, every organization is different, and you might have resource constraints. But again, to the extent, and we'll talk about controls a bit more in just a minute, identify the situations that may require legal counsel. And the thing that pops to mind immediately is material event disclosures may need to be worded very carefully. And so I think it's a good idea to have an attorney familiar with SEC rules enforcement to review any notices before they are actually filed. Obviously, the more controversial the event, the more likely a legal review should be included. Even if you hire a dissemination agent, submissions should be confirmed. Ensure that they were made timely and correctly. None of my audit clients had this issue, but I've heard from others of situations where the obligated person prepared their annual disclosures timely, forwarded it on to the dissemination agent, but the dissemination agent posted them incorrectly, so they could have just indexed it to the wrong bonds or failed to index it to all the bonds, or they just didn't get them filed or posted before the deadline. And, I've heard stories that there was quite a bit of tension during the conversations leading up to the decision to self-report because on one hand, the issuer feels like we've delegated this responsibility and we've got procedures in place that should ensure all our filings are posted correctly, but basically our third-party vendor failed us. But ultimately, I think everyone needs to remember it's the obligated person's responsibility, despite any third-party arrangements. Procedures, I think, should highlight the differences for each type of disclosure. So you should formally document workflow and all the associated tasks for each one of these sub-processes. So for new issues, that's your primary disclosure. Highlight who's all involved. There should be an approval process before a preliminary OS is approved and released. That may involve the audit committee or the board of the organization. You're going to have a different process for the annual filing cycle. It's not a bad idea, since the annual filing requirements are really downstream from your annual close calendar and the preparation of audited financials. Embed the procedures related to disclosure into that close calendar process. That way, again, you've got more control. The organization is well aware of it, and it's less likely to fall through the cracks. Voluntary disclosure, I think that's one where that's another area where it's a good idea to consult with legal counsel to find out what's a good idea versus what's a bad idea. My personal belief is only disclose what's required, but there are varying opinions across the country on that topic. Again, it's a good idea to speak to counsel about what's appropriate and how do you manage consistency in your voluntary disclosure information and the required annual filing information. You don't want to say one thing in one place and contradict it in the other. And then ongoing training, your procedures should highlight how are you going to train the staff that's involved in the annual filing process. The regulatory environment changes over time. For example, the rule was amended in 2010. So as the rule changes, your staff needs to be aware of those changes and adapt the procedures accordingly. So once you establish good, detailed, written procedures, make sure embedded in that process is at least an annual review to make sure that they're still relevant. And that's where we're kind of getting into the discussion of embedding appropriate controls. I highlighted earlier, consider how segregation of duties will improve the outcome. I highlighted above, does it make sense to have the same person preparing, reviewing, and filing each document? Probably not. But if you're a very small organization, you might not have a choice. Documentation and training, as I mentioned earlier, very simple types of controls. You're creating a safety net to make sure something isn't overlooked. Consider the use of formal certifications that disclosure content is accurate and truthful. Certifications can also be used to confirm postings were filed timely each year. And I'll share a simple example of how a checklist and other tools help with this filing process in just a bit. I know this last control may be a little bit unsavory for some, but if your organization has an internal audit function, ask them to test your procedures. Ask them to sample it and make sure that your procedures are being executed and they're effective as designed. Okay, next I'm going to talk about just a few additional helpful hints. During our peak review season over the summer, I was quite frankly surprised at how many clients could not forward us a complete listing of the debt that was outstanding in the last 5 years. And from our standpoint, when we're trying to understand what the universe is, it takes us a long time to try and triangulate that and pull it all together. And since having a debt roll forward should be part of the annual financial reporting process, again, that's an integral step to preparing the notes to the financials. It's an integral step to preparing the annual disclosure filings. But again, all too often we had to figure out what the universe was on our own. And the clients who proved to do a good job of managing their disclosure undertakings all had, some called it a bond genealogy, others called it a debt inventory listing. But each time there was a new bond issue, they would update this inventory, and if an existing bond was retired or defeased, they would also account for that as well. And so on the next slide, I'm going to cover an example of one of those with some of the basic elements. And again, it's the folks that we audited that did a really good job. This is a common denominator. They tracked their debt in a great deal of detail. It sounds like a lot of work, but ultimately, I think the results proved that it was worth it. Another common theme that we found, and again, you've heard me say this several times, especially for revenue bonds, is that the CDA requirements evolved over time, even for bonds that had the same credit type. And as I mentioned earlier, I think the financial crisis had something to do with some of these changes. But when we perform disclosure audits, we create a table that summarizes the CDA requirements across all the issues. And that helps us tremendously with evaluating the completeness of a filing. There are so many moving parts. It's just you can get consumed by the details. So we found that this is a good tool for reconciling a new issues requirements with those of past undertakings. And again, I'll show an example in a couple of slides. But some of our audit clients have come back to us and thanked us because we forwarded the Excel version of this table, because they fully intend to use it going forward, just to roll their debt and account for everything at the CUSIP level, everything at the CDA level of what they need to be including in their annual filing reports. The last thing here, leverage technology and office tools. Again, this is Captain Obvious speaking, but you can set up ticklers through Emma. You can set up ticklers on a shared office calendar. You can, like I mentioned on the previous slide, embed it into the close calendar. Or you can use, if your organization has a content management software solution. A lot of these CMS systems have automated workflows. We've created a post-issuance compliance monitoring tool out of a content management solution. It allows us to automate the workflows. We can automate the certifications. And then the other thing is you can subscribe to ratings agency alerts. So when you issue a new bond and it's a rated bond, subscribe to the ratings agency. They'll send you an alert if there's any ratings event. And then you can ask, your dissemination agent should be doing it anyway, but any other parties involved in your compliance efforts, include them on that distribution list. Okay, so this is an example, as I mentioned before, of a debt inventory. Some folks call it a bond genealogy, but it's pretty straightforward. And what it does is it lists the bond series, the issue date, the par. So a lot of these different data elements could be relevant to other types of compliance activities. So I'm a fan of one-stop shopping. So I like the idea of just putting everything in a single summary. Notice that everything's tracked at the CUSIP level. I think that's important because when you post filings to Emma, you're going to index them to all of the relevant CUSIPs. And so as new debt comes on and old debt is retired, you can account for that here, and then essentially you already have the CUSIPs. You're streamlining the process for when it's time to file. And to illustrate how you account for retired debt, don't delete it off the sheet. Because again, this is, as I mentioned earlier, it was very difficult to determine what debt was outstanding during a 5 or 10-year period because it evolves. So some bonds come on, some bonds go off, but it's a good idea for at least the 5-year statute of limitations period, keep tracking the debt that's gone away. That way you memorialize it. In this bottom section, if there's a bond issue that's exempt from the rule, you can track that as well. And so now you know why you're not making a filing and why you're not indexing those CUSIPs. It's not a bad idea to go ahead and track, who are the ratings agencies connected with each issue, and the credit provider. If it's got an insurance, then track the insurance provider and then sign up for alerts with the ratings agencies on those third-party credit providers. And then, again, this is a good way to track. Different CDAs have different due dates. Some will say 180 days, some will say within 6 months, some will specify a specific date. So this is a good way to just get it all down in a single place, and then you can reconcile what is, you want to go to the lowest common denominator here. So we need to get all our filings, for this issuer in by December 27th, 2015. And down here you've got some more stringent requirements. So it's an easy way to as a dashboard to better understand what your requirements are, and again, one-stop shopping is the phrase of the day. All right, okay. Here is an example, I alluded to this earlier, of a CDA summary. Very simple spreadsheet. It's just a table. And what you can see here is what we've done is different OSs will refer to different types of operating data. And sometimes things roll off, sometimes new things are added. But this is a good way, it's very detailed, but we're ticking down, again, lowest common denominator, what needs to be included in our filings. And to the extent that you can prepare a single document that covers all of these requirements. For example, this 2007 bond has a new requirement to include information on faculty and staff statistics. So this is obviously one for a college. Whereas the other don't. The others did not. Bottom line is, I don't think it hurts to go ahead and include that. You can file a single document for all the bonds. Again, I included this just to illustrate how a simple spreadsheet or table can be used to highlight the differences in requirements. You can use it as a checklist. You can use it to reconcile. But very simple tools, documented procedures. These will help you maintain a good, efficient, and effective compliance process. And with that, that concludes the presentation. And I think if anyone has any questions, we'll go ahead and try to address those now. This slide here shows the contact information for both Brad and I. If you have a more detailed question that perhaps you want to follow up with us, feel free to do so.
Thank you all for your participation today. We have 3 questions that have come in. One is does the SEC rule apply to conduit issuers? I'm going to unfortunately have to give you a nice lawyer-like response and say it depends, because different conduit issuers have taken different approaches to how they want to handle continuing disclosure undertakings under Rule 15c212. In certain instances, the conduit issuer made the continuing disclosure compliance the obligation of the conduit borrower. If they did in that case, then the MCDC program may not apply. But if a conduit issuer took the responsibility for ensuring compliance by the conduit borrowers, then it very well may apply to the conduit issuer. So unfortunately, I don't have a nice concrete answer for all different situations, because I think it all depends upon the different facts and circumstances. Instructions for filing: do you email or mail the report in? You can find the instructions on filing on the SEC's website. A quick Google search, SEC MCDC, will actually take you right to the page of the SEC that will provide information with respect to the MCDC program. You can actually mail your report in or your questionnaire in. You can email it in, or you can use that dinosaur technology known as a fax. The question with respect to the slide presentation, will it be available for the people who participated today? Lisa Marie can correct me on this, but I believe that it is going to be available. I just don't know when. Lisa Marie, I don't know if you're on and you can comment on that. Yes, slides and reporting will be sent to attendees early next week. She answered the question for me, so she didn't even have to chime in. Very well, folks. We appreciate your participation today. If you have any questions, please contact Matt or me. It is it's a very interesting time in the municipal securities market, and there are a lot of uncertainties that surround this, simply because there really hasn't been a lot of guidance provided. The best course of action is to engage and I don't want to make this sound like an infomercial here, but your best course of action is to actually engage your counsel and have them walk you through this process. Thank you very much for your participation.